Judiciary Committee this Tuesday afternoon, February 3rd. And we are going to get to H566, but first we're going to get a rundown and overview of the 2025 Domestic Violence Fatality Review Commission report. And we'll ask Willa Farrell if you could join us. Right, I have the wrong one. I sent the wrong one. I apologize.
The correct one is.
The correct one is.
I'll print it.
Okay, that makes so much more.
That would be my fault, not Nate's fault. I was like, well, you can talk about this report too if you want, but you know, I apologize. But if you could join us, and is it online as well?
Yes, the correct one is online. All the documents that Will sent are. Yeah.
All right. So it is online, so we at least can get started, and we will have this printed off. Sorry about that. And if you can identify yourself for the record and proceed, thanks for being here.
Good afternoon. My name is Willa Farrell. I work at the Attorney General's Office in the Community Justice Unit, Court Diversion plus Pretrial Services Director. Thank you for the opportunity to come and speak to you about our annual report, which we submit every December and provides a brief overview of the services that we fund. All of the services are statutorily based. And before I get into that, I really just wanted to speak a little bit more to the people who do the work. So there are about 80 people who are supported through the grants that we provide. When I look at budgets, it's more like 50 full-time equivalent. People obviously have different jobs that get matched up with different funding or might work part-time. But they're one of the more committed group of people I know who are really passionate about their work, passionate about restorative justice, often going the extra mile in terms of supporting victims, finding that balance of support and accountability for people who commit crime. And although court diversion and pre-charge diversion are, I think, often viewed as alternatives, and they are outside the standard criminal legal system, they are definitely key components and essential to the operation of the criminal justice system in Vermont. And every year we do visits at 3 organizations. We fund 12 organizations. And we call these our quality assurance visits. And as part of that process, I ask state's attorneys, the local defense bar, judge, law enforcement, other folks in the community for feedback. And I just happened to get some comments for an organization I'm visiting later this month. And I didn't get anyone's permission, so I'm not going to attribute them. But I just wanted to give a couple highlights. So a state's attorney wrote about how responsive this organization is to the needs of our community and to holding offenders accountable. We get such positive feedback from victims after completion of the restorative process. And then his next paragraph, he spoke about the timeliness of the work, which I thought was particularly relevant given many discussions these days. The office also works in a very timely manner in each step. Timely information provided to all parties to keep us updated. Persons that do not engage are returned in a timely manner. That's all really speaking around the court diversion process. And then pretrial services, which is not a restorative justice program, but a way of helping people, defendants, get access to services as they're going through their court case. This prosecutor wrote, the services are amazing. The organization is able to keep track of people and keep them engaged in cases I would not have thought possible. Such a help in resolving cases. So I wanted to just highlight to hear from some direct stakeholders about how these services are valued. There's a lot of details in this report, primarily about numbers. I thought I might touch on each of the components we fund and just draw out a single point and then sort of leave it for questions. program I want to highlight is pre-charge diversion because that is new and was really, I think, an outgrowth of this committee's work. And as of last year, July 1 was the first year that pre-charge diversion fell under the umbrella of the Attorney General's office. So you won't see any data in our most recent report because it was issued a few months into our starting with pre-charge diversion. The legislature also added a position to our office in at the end of September. I had a colleague join me, Kelly Ahrens, who was sitting next to Kim McManus over in the corner there. Kelly came to the AG's office with 10 years at the Burlington Community Justice Center. She also has worked at the Franklin Grand Isle Restorative Justice Center and the Brattleboro, what was then the Brattleboro CJC. So she has a real depth of experience doing restorative justice practices, and she has an experience of systems thinking. She supervised a team of 5 in Burlington, and I would say I've never known anyone hit the ground so quickly. Last month, January, Kelly visited the last of the sites around the state, and the themes that she has brought back are both about the system as whole, as well as about what the work of our office can be. And so some of the highlights I really wanted to draw out were how pre-charge is valued for being swift. The swift response is really the common theme that people speak about. And really the need of our office and in partnership with providers to help provide standard forms and information and training to law enforcement to explain these new services. There is a strong desire to really uplift the work with victims, and that is a key component that was really strengthened, I think, in Act 180. And so we're hearing the same thing from community providers. Kelly and I and Anne, who works in our office, also have a goal of updated manuals by July 1. We're doing that in partnership with all the community providers, as well as the Center for Crime Victim Services, the state's attorneys, and public defenders, and also the Office of Racial Equity. We're launching a new sort of training statewide meeting flow starting next July, and working on new visuals and documents that can be used in different settings to explain the full array of the services that are pre-adjudication and supported by the AGO. There's a lot of work, but it is also very energizing when you have somebody who has new experience. And so I would just say for me personally, it has been a real shift in our office. And I think also from what I hear from community providers, some really nice, really very nice affirmations of Kelly's approach, style, and knowledge. So stay tuned. Next year's report will have a lot more about pre-charge. A few points I highlighted to just note around post-charge diversion. And I don't have the actual words, but Jen Pullman from the Center for Crime Victim Services has really made this point in meetings, is that often the crimes that people might call low level do not feel low level to a victim, and that the work and support that community providers can give, and it may be they can't resolve, the victim may have their restitution paid, but there's a certain restoration of trust. All of those sort of more emotional needs can be met to a certain degree by someone who's willing to listen to you. And that is a huge piece of the support that people provide. An interesting aspect about post-charge court diversion is the number of cases that come to us for the crime of driving with license suspended. So about 20% of the charges that end up in court diversion in criminal division are DLS. So it's just a thorny problem, and those cases often stay in diversion a long time because people are putting aside money to pay for IDLP or a fine out of state in order to be able to get their license reinstated. But the work that diversion staff do is invaluable in helping people navigate the system. It is not necessarily a simple process. And also to help people do budgeting or strategize which of these requirements does it make sense for me to satisfy first. Pretrial services. I want to make the distinction. This is separate from pretrial supervision. Pretrial services is initiated when a judge issues a court order asking the individual a defendant to engage with pretrial services staff. And it might be to get a screening or a clinical assessment for substance misuse or mental health. Pretrial services staff also work with people to remind them of their court hearings, connect them with community resources. Often it's like the recovery center or other maybe less clinical, but equally valuable support services for people as they're going through their court process. Recently, what I've been increasingly, the issues that pretrial service coordinators are helping people deal with around health and economic needs, I think have been highlighted through the judiciary's workshops they've been holding around the sequential intercept model, and also the governor's PSET, Public Safety Enhancement Team. I think the T is a different letter, which is has led to these situation tables in different cities, primarily, or larger communities in the state. And it has been, I think, an interesting reflection of not overlapping, but interlocking efforts to find the best way to get resources to people and get people connected to the supports they need at the same time as they're being held accountable for the crime they've committed, or in many cases alleged. Finally, the Youth Substance Awareness Safety Program. This is a civil violation program. So these are youth under the age of 21 who are referred by law enforcement for possession of alcohol or cannabis. And as of last year, as of July 1, also 0.02 violations, which is when a person under 21 drives with blood alcohol content above 0.02, but lower than 0.08. We hit the ground on July 1, and so it's been a little rocky in terms of everybody, meaning law enforcement, the Judicial Bureau, and our grantees knowing, well, what is this new law? How does it work? How does it play out? We have developed curriculum, may be a strong word, but a solid framework for how staff work with youth referred for this violation that includes the screening process that we've always done, but also an additional educational component. Youth develop a no driving plan because they are under suspension when they come into the program. We have these workshops that talk about the consequences, both to that individual as well as broader society, for what driving under the influence. And then youth develop what we're calling a sober driving plan. So for when they are reinstated and eligible to drive again, how will they drive sober? It feels like a feedback, and we're asking staff to ask participants, what do you think about this? And we're getting some useful feedback. Like, that video was too juvenile for me. I'm 20, and that's really geared for a 16-year-old, that sort of feedback. So it's a work in progress, but staff are giving good feedback. There are, I think, as Chair Lalonde knows, some areas of the law that we would like to suggest some changes to regarding the process by which people can contest the suspension, which goes into effect as the law is written now, 11 days from the date of the incident. And the way the law was passed last year, for these violations, people have to go through the Rule 75 process. So we have some suggestions, and we'll be sending language to the committee soon for your consideration. And then there were a few other more housekeeping related issues, which I won't go into at this point. The final piece I would like to highlight around our work is data. We're increasingly collecting more data. We're working with Crime Research Group. Monica Weber and Robin Joy added to their existing federal annual grant, working with us to look at our data, what data points we collect, how do we use those to develop meaningful outcomes, and how do we report those. It's pretty intense work because we're trying to be both realistic about what can we be held accountable for, what data can we collect, is it really a data point we need? Are we going to use it so that the staff really are spending more time doing work than entering data into our pretty old clunky system? Our goal at this point is July 1 to make some changes. So the data we report next December won't necessarily include changes, but we might highlight what we're doing in that report so you can see in subsequent reports. Those were the highlights that I wanted to bring to your attention regarding the report. We tried to keep it brief so that given all the reports and documents you receive, you might feel enticed to read it. I'm happy to answer any questions either about the report or information I've shared or anything regarding the work our grantees do, which maybe I should note there are 12 grantees that provide the full array of services. And this year there are also an additional 4 other providers who are just doing pre-charge diversion in this fiscal year. And in Chittenden County, we're working towards having just 1 provider for that county.
Angela and Todd.
Thank you so much, Willa. And I think my question is probably most relevant for the Chittenden County situation. I was just wondering if you could characterize the phase.
Yes.
What phase are we in this transition, or what's been done and what's left to do?
Certainly. So starting in July, we've been having monthly meetings with different configurations of stakeholders, for lack of a better word, within Chittenden County. Those meetings have included town managers as well as CJC staff and either the police chief or a deputy police chief, sometimes both players. We've been in the most immediate sort of stage because of data collection reasons. All of the CJCs include their data in a common Excel spreadsheet, and then the Burlington Community Justice Center enters that into our system. And that is useful not just for data collection purposes, but also for case coordination. And sometimes people are involved in more than one program, or sometimes there's another incident that happens, and so that communication happens. But from the beginning of this fiscal year, the conversation has been about the transition, because everyone has known that in FY 2027, the AGO will only be funding the Burlington Community Justice Center, which is the current provider for the other array of services. So there have been surveys sent to volunteers and staff. There are 2 upcoming listening sessions that you may well know of. And there's discussions about a new name. There's discussions about shared governance. What would a new advisory board look like, be composed of? How will information be relayed back out to the municipalities? How will staffing be configured such that there retains a presence in all the communities where there is one now? And this is, I think, relevant, but not specific to pre-charged diversion, but because of other funding changes separate from the Attorney General's office, there are not necessarily funds to do some of the other work that those 3 community justice centers have been doing. And there are discussions that I'm part of, but are not privy in terms that it's not directly related to the AGO, but about how might the Burlington CJC provide this service that another municipality was provided. So there's the discussions that are happening really are much broader than just around pre-charge diversion. Oh, as you can imagine, they're challenging conversations. There's, change of staffing coming up, and it's not necessarily easy for people, and change is like, change is hard. And I think there's increasingly just a recognition of the value of having these services under one umbrella, and that everybody is here to make sure it works for all the players, like for victims, holding people accountable, for law enforcement. And it has felt, it feels like productive and positive discussions overall, from my perspective.
Great. And I think a part of, if I remember correctly, a part of H645. What's the
180.
Act 180. I don't know if this stayed in there. I could just. But there was that part about the wider conversation and about trying to figure out how services outside of pre-charge diversion could continue to be provided in those communities, potentially with those, perhaps funding from the municipalities or what have you. So it sounds like those conversations are ongoing.
They are, yes, because most of the community justice centers have municipal funding supporting them to some degree to do other services. So I think those are the local conversations happening. It's like, if we have these resources, what's most important, and what do we want to be funding?
Thank you, Mr. Vice Chair.
Oh,
Tom,
Tom
maybe
was
it's-
next, sorry.
We also
How
have-
many actual pre-charge counties have pre-charge up and running?
We did not fund 2 counties this year, Rutland and Orleans. So the pre-charge that is happening there is only youth pre-charge under their DCF funding. So not a lot. All the other counties receive funding from our office to do either continue pre-charge that is already happening or to start. And I could get you the actual list, but about half of the counties had enough pre-charge that they already had identified staff and systems in place. And then, so that leaves, these are really 4 or 5 counties where it was really starting from scratch. And that those, it's happening, it's starting. All the state's attorneys have policies and have spoken with there's conversations locally about how this is rolling out. But it is the level of or amount, if you will, of pre-charge.
How many, or not how much? How is engagement be most effective? Where are they coming from to get into how they hear about it?
Really just I should say in some counties, it's the state's attorney who reviews, a law enforcement officer will send a case to the state's attorney's office and may recommend pre-charge or may not. And the state's attorney then is making that referral pre-charge, not filing the charge. In other counties, for example, Chittenden County, where it's the most pre-charge in the state, it is law enforcement officers who are sending the referral directly to the community justice center. And we've,
Bypassing the state's attorney.
yes, under the state's attorney's policy.
Oh,
So each state's attorney has indicated whether they wish law enforcement to send those directly to the provider or whether they wish that to come to their office for the state's attorney to make the decision, whether it goes post-charge or
is that
prosecution.
because they have their hands full with the versionary stuff too or something? Or?
I think it's probably a multitude of reasons for their policies. Yeah.
So my only question, actually two questions. One, am I doing pre-charge diversion when like something is like just like, okay, this should go to diversion, file it with the court and then show up at arraignment and my great diversion guys are around the corner.
Mhm.
Defendant says, yeah, I'll take diversion, and we never actually do the arraignment. Is that considered pre-charge or is that still?
That's post-charge.
That's post-charge.
Yes.
Okay. This is partially because I wasn't here when we
Yeah.
did all of this, so I don't quite understand.
Give you a tutorial.
Yeah. Okay, that was my one question. And then
Well, actually, if I may interrupt, we have a new visual
oh,
in the draft stage. So if you'd like to give us some feedback, we would welcome it.
cool. Yes. So that was my one. That's very helpful. And then the other one was just so 20% of pre-charge diversion.
Post-charge.
Oh, post-charge diversion, yeah, or DLSs.
Yes.
Is it like an effective way to resolve those cases, given like how many of, because I imagine some of those are DLS like subsequent, like
Right.
3, 4.
Yeah. Effective is an interesting word. I would say it's more effective than somebody being convicted and given a fine,
Yeah.
which is probably the alternative. I do frankly worry about the consumption of diversion resources. And yet, I mean, and I talk to staff like, oh, you've had the case open so long. You're like, what are you know, like we should be moving cases quickly through diversion. And people legitimately, and I have to agree with them, it's like, well, if I can help keep this person on a payment plan and they can pay off the $1,000 they owe Massachusetts and then they're eligible to get their license back, that's a good outcome. And I have to say, yes, it is. So it's, you know, my druthers is people weren't charged with crime, but that is the reality. And so it's effective to the degree that a person has enough resources and few enough crises in their life that they can stick to a plan to, for the most part, it's saving money.
Yeah.
So that they can pay the IDRP fee or pay off an out-of-state fine, because this committee has done, and Chair Lalonde really has led a lot of that work to really limit how much this is, you know, people get inundated with fines and how to make it possible for people to keep driving legally. That wasn't the best expression of what I'm trying to say.
No, but I totally, again.
Yeah.
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 No, that's helpful. Thank you.
That number increased. The number
DLS?
20%.
I'd have to look. It's probably comparable. I mean, it's
At some point it increased.
yes. I'll look it up.
Do you think that's in part by the way we handle our traffic justice system up until you become criminally suspended?
Meaning that you have 3 civil before you get criminal?
Well, you have civil tickets, but you also have it's not as strict as it used to be. We removed suspensions for failing
Right.
to pay fines and all sorts
Right.
of things. There's less risk when going out on the road to
Yeah,
put your license in jeopardy, so to speak, and then all of a sudden you're. I don't know.
yeah, I don't know the answer. I think because I've seen diversion work with DLS, people charged with DLS for 18, 19 years now. My sense is it hasn't been a big, like, I think the reality is people drive, they lose their license and they keep driving, you know, regardless. I don't think most people know what the penalties are
Gotcha. Thank you.
until they receive one.
Right.
So do you anticipate that, we're gonna expand to Rutland and Orleans this coming
Yes.
year?
I've already informed the program directors in those two counties that we will be funding at least probably a half-time position in those counties. Not all counties receive funding for full-time based on various factors. But yes, they will be receiving funding and they know that.
And can I anticipate that this equivalent data that you're gonna be having as far as the number of
Yes,
or pre-charge referrals and success rate and those kind of things?
yes. And we're also adding data by crime type, so referrals by crime type. And this, we're also with pre-charge diversion. I don't think we put in the report, but we could if people wanted, do it by law enforcement agency so that we can send that to each law enforcement agency so they can see the number of cases stemming from their agency and what was the outcomes. I mean, they'll get those individual notices of successful completion or not, but it would be a way for them or for the police chief also to see that aggregate data. So
Make much sense, I would think.
we've already shared that with police chiefs in Chittenden County and got some feedback about how to change what we report.
Okay, great. Angela?
I have a thought on that, in that same vein, looking at page 5 of the report, the referrals by race for court diversion and pretrial services. Would it be possible in future reports to add a column that shows like the total cases? I mean, eligible cases, you know, I'd be curious to know like what, I think referrals column is just the straight number of referrals.
Yes.
And the percent of total is the percent of the total of referrals.
Yes, correct.
Referrals. So I'd be curious to know like what percentage of the total eligible cases or offenses are being sent to court diversion or pretrial services, you know, that sort of thing.
So the challenges there is we don't have those data. We don't know, well, how do you define eligible? That varies by county's policy, and it's also, I think any state's attorney would say, well, and it does, it depends on the individual. So like, take this charge is not always equated to this charge. So it's hard to like have a definition of eligibility. Plus, those are data that would be held either by the court or for post-charge, and they don't necessarily have race data. Or I think those race data are law enforcement based, and we do it based on reported. So there's, from a researcher perspective, I don't think we have we don't have the data, and I don't think we have the sophistication to know how to present it in a way that would be meaningful. And even the data we do submit, you know, I call it a bit of fruit salad because I'm using some court data and then I'm using some of our data.
Gotcha.
It's because we've done it for years and things stay about the same. I feel like there's legitimacy there, but it is not. And that's why you see a number of data caveats in the report.
Right. So, and I thought I read the data caveats. I didn't see this answered in there, but do you know, for the pretrial services, you know, just looking at the difference, the numbers by county, it makes me wonder how much these numbers depend upon the availability of services, or is it pretty relatively equivalent throughout the state?
I would say the availability is equivalent in that each county has somebody assigned to do pretrial services, and they are in the courtroom during arraignment. So whether somebody is issued a pretrial service order depends on a number of factors. Sometimes prosecutors recommend them. Sometimes judges do it based on a recommendation. Sometimes judges do it based on their own, like without a recommendation. I do think probably there's local variation based on, oh, it's a new court, somebody new being hired. Somebody may wait a bit to get a sense, is this person as good as the last person before I start issuing orders? I mean, I feel like I'm just adding to the caveats, but there's so much human variability in this work that I believe the data are important and can tell us things, but they're also there are limits.
Well, thank you very much. So we're going to move you off for a moment and have a walkthrough of 566. And then we'll bring you back to testify on that. But thank you for the updates and the overview of the report. Appreciate it.
Thank you.
And, we're getting that bill passed out right now. Thank you for being here, Michelle. Nice to see you.
Thanks for inviting me in. For the record, Michelle Childs, Office of Legislative Counsel, and we're taking a look at H566 related to sealing post-charge court diversion records upon successful completion. And I'm going to do my little caveat, which is that I don't think I've worked on diversion for more than a decade, because that's kind of falls into our third judiciary portfolio. So I'm kind of pinch hitting now while we're getting Hillary up to speed on things. But
You are our expungement expert, though.
sadly, yes, I am. So I can discuss that, and I'm so grateful that you just heard from Willa. And so there's a lot of things that I probably won't have to go over, which is kind of the differences between pre and post charge diversion, right? So this bill is only dealing with post charge diversion records, so not the pre charge. So there's no changes to that. So you remember with the pre charge, because the post charge means that there has been there's been a charge filed and there's been probable cause found by the court, right? So for those cases, when you're talking pre-charge, that's something that can be done by the law enforcement officer or the prosecutor, but it's not yet gone to the court, right? So it's an earlier stage. And so for those, we're not talking about those records. There's an existing provision, and the provisions are the same in both the juvenile and the adult diversion programs in terms of what they do is that upon a couple of years after successful completion, those records that were held by the law enforcement agency, by the state's attorney, and then the attorney general, those are deleted. And that's the term. So they're gone as if they never existed. Remember, it's never filed, right? So if there's a successful completion. So, but with the post charge, right? So there has been a determination of probable cause, right? And so with that, there's this record, right, in the court with the attorney general's office, with the state's attorney's office. Law enforcement will have some records. And under the current law, there is a process that says that those records upon successful completion, like within 2 years after successful completion, that those records are expunged. And this committee knows that there's a big difference between sealing a record and expunging a record. Expunging a record means it's gone, can't access it under any circumstances. But what you did with the sealing bill last year is you changed the general statutes with regard to sealing and expungement to make the vast majority of offenses that you have under the qualifying crimes to be eligible for sealing, not for expungement. And we made a policy decision that it was important to retain those records for certain purposes. And I remember that subsection C of 7607 that you spent a lot of time talking about, who has access to those sealed records and for what purposes. So, big difference between expungement and sealing. So right now it's expungement. And I think this issue came up in the context of your discussion of that bill last year. And you decided, well, you know what, we're going to wait. We're going to hear a little more from different perspectives, get a report, talk to folks and figure out whether or not it makes sense to extend that change from expungement to sealing to to post-charge diversion records. And so that's just what this bill does for both the juvenile and the adult court programs. And so I'll walk you through quickly. So section 1 of your bill, and this is just it. We didn't put in most of the statute because it's not changing anything, but with regard to the records upon successful completion. So you'll see in section 1, this section is dealing with the juvenile court diversion program for post-charge diversion records. So within 30 days after the 2-year anniversary of successful completion, the court is to provide notice to all parties of its intention to order. And now you see everywhere that it says expungement, it's just switching it to sealing. So for the intention to seal all the court files and records, law enforcement records, fingerprints, photographs, anything that is in the criminal justice system that has some type of record relating to this particular charge. It's not changing the criteria for the expungement / sealing. It's the same. The state's attorney has an opportunity to come before the court and contest the sealing if the state's attorney wants to do that. But the court is to order the sealing of the records if it finds that 2 years have elapsed since the successful completion of the program. The participant has not been convicted of a subsequent misdemeanor or felony during that 2 years since they successfully completed, and there's no pending charges. And the participant has taken care of any restitution that was ordered. So again, no changes here. The only changes in here are talking about do you expunge or do you seal? There is some language on page 2, subdivision 6, that's been repealed because that is talking about some retroactive application of expungement that is no longer necessary because of the direction that you're going. You look at page 3, there still will be an index. Right now there's an index of expunged ones. This would be for field documents. It's about who can access that sealing. I did have a question just because I can't remember. I don't think maybe I picked this bill up after it had initially been drafted or something already by then, but so I wasn't involved early on in this, but is the access to sealed records in 7607. So who can access under what circumstances applies in the same sense for this or no?
Yes, I think.
Okay. I would assume that it would,
Yeah.
but I wasn't sure and I was thinking about it and I'll have to go back and look at it and wonder if maybe it's helpful to put in a cross-reference or something there, but just because they're in different titles. I don't necessarily think that you need it, but I'll take a look at that.
That was the intent, but
Sure.
obviously we can have a conversation about.
That's like for a legitimate law enforcement purpose.
Correct.
Yeah.
Yep.
Okay.
Yeah,
Yeah, I guess that would be the same.
I would make that assumption, but
Never hurts
I
to be
just
very
raised
clear.
it as an issue as I was looking back at this one.
Yep.
So I think if you move on to page 4 and you see subdivision 9, so starting on line 6, and this is so the process of automatically sealing records shall only apply to those persons who completed diversion on or after July 1st, 2026. And so that is, I assume, intended to match up with the ability for starting to do all of these sealings. And so starting with the effective date of this act, right? So we're not going back. So folks who are in the process now will be operating under that existing.
Well, I just want to make sure I understand that previous point. So you're going to cross-reference to what can be done with sealed documents. Is that what I was understanding?
The access.
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 That's what I mean.
By who? But I don't know that it's necessarily needed. I just brought it up
I think
as a point because if I had the question, just reading it through as somebody who knows very little, honestly, about the diversion in the last 10 years, then, might not hurt to put a little pointer because again, you're in a totally different title.
Right, but how those sealed documents can be used would follow the same that we spent all that time in last.
Correct.
Right, okay, that's where the cross reference.
Yes.
Okay, I just wasn't following you at the moment, but down.
Yes, and I can share that if your question is, Barbara, what, I don't mean to cut you off, but it is, what did we just do? Because I had to go back and look and, or no, okay, go ahead, sorry.
So before we get to the adult part, I just want to make sure I fully understand. So let's say somebody at age 15 went through this process and their record got sealed.
Mhm.
That index will exist for all time. So if that person does not get into trouble with the law until age 30 or something,
Mhm.
they will be able to see that somebody at age 15.
I think that's the way it currently works and there's no change to that.
Fully appreciate that. Or not appreciate it.
It doesn't mean
People
that-
have access.
Yes, there's only limited people who have access. So if you look at the index, so it has limited information and it says, if you see it's 7C, inspection of the sealing order and the certificate may be permitted only upon petition by the person who is the subject of the case. The chief superior judge may permit special access to the index and the documents for research purposes pursuant to the rules for public access to court records. So I think you probably need to hear from the witnesses about how they access. So like if it's sealed and it's a sealed law enforcement, how they specifically are, it's kind of under the old, under the bigger system of how are they accessing sealed records.
And I'm sure I had the very same concerns when we did it last time, but just in terms of our juvenile justice system and rehabilitation and thank you.
So section 2 is the adult court diversion program, and it is essentially the same changes, although I will note that on subsection A, on the purpose, there is an expanded purpose. So you see subdivision A2 is that right now it's to provide a restorative option for persons alleged to have caused harm in violation of a criminal statute, and then it's adding or a municipal ordinance. Right, so some towns have the ability to be adopting a municipal ordinance that would fit the criteria for that might otherwise be a criminal offense or something similar, and this would include those as well. So again, the changes are just to the same thing. If you look at page 6, changing expungement to sealing. No changes to the criteria. So the timelines are the same. So it's 2 years have elapsed since successful completion of the diversion program. They haven't been convicted of a misdemeanor or felony during the 2-year period, and there's no pending proceedings regarding another criminal offense. I did have a question there about whether or not, since it is, because with the addition of the municipal violation, whether or not any kind of, I'm not making a suggestion that you change it, but whether or not there's a different analysis on this one.
Can I ask a-
Yeah, go ahead.
just, where did the municipal ordinance edition come from? Okay, we'll ask.
And we have witnesses that will be able to
Yeah,
speak to it.
And, again, the changes are the same with regard to just changing expungement to sealing. There's still going to be an index. And you look at the last page on page 8, subdivision 9. The process for automatically sealing applies to those who complete diversion on or after July 1st of this year.
Any questions? Any other questions? Well, not seeing any. Thank you so much, Michelle, and invite Willa Farrell back. We'll get this the hot seat there.
For the record, Willa Farrell, Attorney General's Office. Thank you for the opportunity to speak on H 566. I thought I would separate my comments out around the expungement ceiling change and then municipal ordinance. I will say that in general, the ability to have one successful diversion record expunged is very appealing to individuals. It is a motivator, and it is a significantly different than sealing for people and for the how people view their record if they complete diversion successfully and have no further criminal involvement. That's how we understand that prosecutors and law enforcement and others see value in having access to sealed records. And we understand the move last year to move towards the sealing provisions than expungement provision. The other piece I wanted to note is within pre-charge diversion, there is deletion of records other than what is in Valcourt. So expungement would be very different post-charge diversion than deletion in pre-charge diversion. So I do think that moving to sealing does align pre-charge and post-charge diversion record retention in a better way than what currently exists, where under the current system, pre-charge case is not totally gone away. You still have the Valcourt record that law enforcement have access to, but a post-charge diversion case would be completely expunged. So the move to sealing, I think, creates more of a alignment, if you will, between pre and post-charge record retention.
So kind of quick questions. I thought state's attorneys also had access to any records they may have received in pre-charge. They had to go on through the state's attorney, not directly from the law enforcement.
Read that
We can
again.
Kim McManus, if I'm just remembering that.
I remember the retention within Valcourt.
Yeah.
But yeah, it's
Yeah.
not positive. Certainly the most important considerations for people about records, as I'm sure you heard last year, I was not here for testimony that you heard, is around housing and employment, and sealing provides great protection for people in order to get jobs and housing. So in short, I guess I wouldn't suggest any changes to this part of the bill. I do think as Michelle suggested, adding a reference to what sealing means and how, what who has access would be important for a person just reading the statute to know where to go. And while this may not be something, it's not a legislative fix, I do think from a standpoint of plain language, when I read that statute, not being a lawyer, I have to go ask lawyers in my office, what does this actually mean? And I think it would really be helpful if state government, whether it's whatever part of state government, could really explain to people what it means to have their records sealed in plain language. As we routinely get questions about what does expungement mean? If I want to go, the main questions we get, if I want to go to Canada, what does that mean? And military recruiters see my records, etc. And so we send information. Often I'm saying I don't know because I don't really know. So I do think as much as we can tell people and be clear about what does it mean to be sealed and who has access would be a good service to people.
Karen and then Angela.
With the assistance of legislative counsel, I got the answer to the question that you were looking for earlier. You want
Myself, but
yes. And so it is for pre-charge, it is records held by the law enforcement agency in the state's attorney's office, of public records held by the law enforcement agency in the state's attorney's office shall be deleted. But then its records maintained on the Valcor database or other similar non-public databases maintained, those can be kept for criminal justice purposes. Yes, so that's the difference, is what is public facing and what is that they just have for their own.
Right.
Which I remember we had that in-depth conversation.
I was kind of remembered it right. The shot in another side. So I guess the question, well, I'm sorry, Angela, go ahead.
Oh, I was, what you were just saying, Willa, about like just having a standard definition or clear description of what sealing is, what it means and what it doesn't and all of that. Do you suggest that that's here in this title?
I mean, I think that might be a question for legislative council, whether that's appropriate. Is that something one puts in legislation? I'm not sure. I mean, I
Yeah,
guess
and I'm wondering where in which, like in where, where in which title? Where
I
in-
think you should put it in 163 and 164 in 3 and either cross-reference if all of it applies or cross-reference the subsections. I'll take a look at it and see if there's things that are already, because remember in what you have in Title 13 in that chapter is you have one statute on effective expungement and another statute on effective sealing. So it goes through the general stuff that we all kind of know by heart, which means, expungement means it's gone and sealing means this. But I'll send you a link to that statute, the committee, if you want to take a look at it, and then we can come up with something and it can run by well.
So would we use then on page 3 and at the bottom of page 3, lines 19 to 20, 21, and then go to page 4, would we just do a cross-reference instead of?
I think a cross-reference as long
Instead
as,
of
but I'm
this-
gonna double check on 7607 to make sure that there's nothing in there
Right.
that kind of conflicts or would be confusing if you read the two statutes.
So presumably the effective sealing, we want to have
Yes.
consistent for different places to seal. That's good.
To clarify though, that you are supporting the cross-reference and you're saying even with the cross-reference, it's not easy to digest. Is there a way we can put more digestible information in here? Which I don't know if we've ever done or if that's a thing. Yeah.
So I don't know, like, for instance, going to Canada, that's federal law. So I don't know that we have much to say on that. Maybe the federal law will change, but I understand what you're saying.
Right, and I don't think that's necessarily what one would put in legislation.
Right.
But I do think, and I'm making more just a statement, that there could be parts of state government who could provide, because that information would change. And I think that information could include things, as I understand. This applies to Vermont. And I don't think, like, what does it mean if it doesn't necessarily apply in other jurisdictions? I think, I mean, this is what I'm just, and maybe I'm going a little off.
No, that makes sense. I just don't know if we direct somebody to do that or if we ask politely.
I'm using the opportunity to put an idea out.
No.
Yeah, and I think it's really helpful because what you're talking about is how these things that we talk about in theory here are used by practitioners in the real world, and that's a really important part of all of it. Yeah.
So we're gonna, go ahead.
I'll just speak about the municipal ordinance addition. The catalyst for this was work happening in Burlington, and I think many of you may have read about the city circle, which is a restorative justice option for within the city of Burlington for police officers to refer people for municipal ordinance violations to restorative process. And the Burlington Community Justice Center approached our office last summer and said, we're planning to do this new initiative in Burlington. May we do it under your grant funding? So I and others, a couple of lawyers in the office reviewed the statute and what was being proposed. And what our office said was, we think what you're proposing meets the spirit of the law, but maybe not the letter of the law. You would have to make sure it meets with your state's attorney's policy. And if your state's attorney agrees to that, we're willing for you to do this as a pilot this year, providing you have capacity and you collect data, and we will bring this to the attention of the legislature. So hence the introduction here to put before you the idea of adding municipal ordinance violations within the scope of pre-charge diversion. I would make a suggestion that the word criminal be added to this, because there are also civil municipal ordinances. And this statute really pertains to crime, and the sort of recourse if somebody is not successful is prosecution in criminal court or family division. So we'd suggest narrowing it to criminal municipal ordinance. And I do have that concern about capacity. I would just put out there, I think it meets the intent of keeping low-level offenses out of the system. Having a speedy restorative response is of great value. And to me, the priority really should be behavior that is more like, crime that would end up in court, and keeping those offenses out of the system.
And then Ian.
Can you give me an example of a criminal ordinance violation?
So in Burlington, I think there's certain, I'm trying to think of well, I will tell you to date, I think they've had one referral. So my capacity concern may be, it's not as high as it was when I first heard about this. And it was somebody, it related to a dog licensing issue and dog behavior.
That's a criminal?
There was something that fit within, I don't remember, but I do know, for example, I live in a small town, and I went on, and apparently my small town has some criminal municipal
Public
ordinance.
nudity, maybe?
Maybe.
I can't
There
think of
is-
any though. Everything
Yeah.
else would be a misdemeanor.
Did they just change that in Burlington?
Yeah.
Oh, there you go.
The city circle is coming to share, as part of Burlington CJC.
Oh, okay.
We'll be able to ask.
Right, we can get that question as, Ian.
So, just sort of, I don't know how to make this a question. But I won't take credit for this because I just texted one of my town attorneys because I was really curious about this. I didn't realize that they could do criminal municipal ordinances. An interesting thing about this is pursuant to 24 VSA 1974 subsection D, is that enforcement of criminal ordinances is actually done by the town attorneys.
Yes.
And so I'm curious, does that mean that we need to have them in to discuss this and not actually for specifically sealing and not expunging those records, how they're brought?
Could do that. I mean, we do have, I'm hoping that we're gonna have chief of police, and maybe they could get part of the answer of that, but I understand the town attorneys may want to wait.
My thought just being your point, that they need to talk to the state's attorney about their process for doing pre-charge diversion. Do they actually? Because it's not really it's not really the state attorney who's going to bring the charge.
The way we read the statute was that pre-charge diversion falls under the policy of the state's attorney, the county state's attorney. And so that a county state's attorney might say, yes, this fits within my policy, in which case in Chittenden County, the state's attorney said yes. But I think possibly a different state's attorney might say the way they limit some, this is not, I don't have a good example, but a state's attorney may say now, I don't want any offense of this nature referred pre-charge, and they might exclude municipal ordinance violations from their policy.
And
That
that,
would be within their purview. So-
it's within their purview, even though it's not within their purview to actually bring that charge.
But to exclude it, I'm not, this.
There's an interesting like kind of intersection between.
Right. No, I mean, right. I try not to pull away the discretion of the state's attorneys, but I don't know if I necessarily want to expand it
Yeah.
to oversee what city attorneys get to do.
It seems pretty clear that they don't, in these cases, have
Right.
any discretion. That's totally outside of their purview.
Right. So we would need to hear from city attorneys. Do you have one that you can find to testify?
Yeah.
Tom, do you have-
I'm just throwing, I think if one of these goes into pre-charge, it's gonna leave the state's attorney and is prosecuted by the city attorney. It's gonna leave the purview of the state's attorney. And there will still be a Valcourt record, but there won't be a conviction there that they can enter anywhere in that system. Because that's entered by state,
So,
it would be a civil adjudication.
right. So this may be more of a can of worms than I had thought. We can't, yeah. So we probably need, is there like an association of? legal cities? Or do we talk to legal cities in town?
I think the LCT makes the most sense probably, right? And I will say just the other thing is that it can be brought by other person designated by the legislative body of the municipality. So there may be someone's charter who says also the state's attorney can bring criminal, like, but I don't think the Brattleboro's charter doesn't have that in. So, and I would be surprised if other ones did. So I think that it's total. So just to your point, like it's not ever leaving the state's attorney's purview. It's just never in their purview.
I'm wondering if we had City Circle come in and like just talk about how they established themselves and got it
Yeah.
started. Maybe they're guests as well, but
It's fascinating.
You can write an ordinance violation in a town on a VCVC though, on a regular traffic.
All right, so,
Yes.
so I guess my question kind of also is this, if a municipal ordinance, criminal municipal ordinance charge, well, pre-charge or charge, I guess. How is it a question of whether the Attorney General is funding that component of the CJC, of the services? Is that really why we need the language in here?
That was the catalyst because we were asked, may we use court diversion money for this work?
Because this is kind of blending into the concerns that I've heard in Chinniconi as far as the CJCs wanting to do other things. And that could be just neighbor disputes or any number of things. This is kind of closer to that.
Yeah.
And if the municipality wants to use the services of the restorative justice, I think it should go through that route rather than through here. It just, an individual municipality can decide whether they want to provide whatever funds the CJC wants to do that part of the work. Because otherwise, I think it gets a lot more, because now we have 14 state's attorneys that get to decide this. How many city attorneys are there?
It's pretty fun though. You gotta do it.
My suggestion is that get a little bit more. We can hear. I'm leaning towards taking that out, and letting Ian put in a bill for next year if he really wants to talk to how many town attorneys there are about this. That's kind of where I am, but we'll hear from more witnesses. But my initial, yes, Barb.
so I don't know if we're done with this
I think, yeah, I think, yeah, no.
I would say we've beaten a dead horse, but that would not be appropriate. No, it would not be. So when you talked about the confusion that people have, I know that like people have to, when they fill out their college application, they're asked if they've been convicted of a crime. Or do you feel like there are clear answers that participants have when they ask that, like on an employment application, what are they supposed to answer?
I mean, I think it really depends on the wording of the question. So if they're asked if they were convicted, we hope people know you were not, if you went through diversion successfully, you're not convicted. Well, we do have a document we send people, but then or at the top, we say something to the effect like, there's the internet. Because people may go through diversion successfully, people may have their record expunged, but if the newspaper or the police blog named them before they were arraigned or referred, that still exists. And we have had individuals who went through diversion successfully who've said, emailed me or whatever, how did they find? And that's why what I do is I put their name in the search engine and I find a news story and I say, this is probably how that employer found out about this. So, I mean, that's just part of the full transparency that we try to provide and include like just all the caveats, not to be. The ceiling is huge. I mean, really, because most employers, most people don't end up in the news, but some people do. So.
Any other questions for Willa? Thank you very much for the testimony. We'll go to Kim McManus. Do you know if we're going to get, who else do I have? Sorry. If Chief Burke is going to be on, Nate, have you heard?
For today.
Okay. Well, that probably means likely. Well, we'll wrap it up. All right. Thank you for being here.
Thank you for having me. For the record, Kim McManus, Department of State's Attorneys and Sheriffs. We were delighted to see this bill, H566. This was not a point that we wanted to push last year when we were working through the sealing bill, but we had, I believe, testified that we do believe it's important to have these records sealed rather than expunged for criminal justice purposes and largely for the data piece, for knowing what's working and what's not working and losing that information after 2 years. We do not have any longitudinal information to see when we send that DLS to diversion, like, is that helpful? Is that effective? And that we would love this information to be available for those purposes. So we support H566. I had one drafting piece that I think it's just an error that I wanted to point out, but I'm also happy to answer any questions. I think you solved some of the questions that came up already. On the municipal ordinance, it is by each municipality as they create it. Some of them do allow state's attorneys to file municipal criminal violations. But you have to comb through and see who can do that, who can't.
Can I just ask a question on that? I'm completely fine if it doesn't survive. Like, I think we put it in, like, let's see where it could go. And I'm like, just you saying that some allow for it. Could it be like in cases where the state's attorneys are allowed to, like, I'm just saying that there could be a path for it. So I appreciate hearing that that is allowed in some of the charters.
I also, and I'm happy to do a little further digging. I remember I was researching municipal ordinances because I was teaching a class and I had to look up what falls under municipal ordinances. And so I just remember combing through Burlington's
And they allow it?
ordinances. I'm like 95% sure, but I'd want to go back and read it, but I don't know how many violations the state's attorney is filing in Chittenden. So I can ask and see, just to see, what sort of scope you would be getting from the state. So I'm happy to follow up on that.
I like that idea. I mean, we can say this by municipal ordinances prosecuted by state's attorneys.
There's a system that's already working.
If
like-
allowed to be
Yeah.
prosecuted, because these again would be,
Don't they use the city attorney to do something though?
the city attorney,
Yeah.
that's primarily,
Well,
that
then
is.
that gets weird again.
Yeah, that's what I mean. They do both.
So sometimes it's brought by the state's attorney, sometimes it's brought by the municipal attorney.
It's an
If it's
option to
brought by the
consider.
state's attorney, then it should be. If it, well, the thing
So
is,
it's
it's
pre-charge.
pre-charge, well, it's pre-charge, well, the pre-charge is different, right? Is this? This is not pre-charge,
No.
this is post-charge, so yeah. if it's-
It would have
it's
to
a-
be,
then
it'd have to be filed with the court by somebody, either the state's attorney or the city or town attorney.
But you create a system where like basically the access to it being sealed versus expunged would depend on whether the state's attorney or the municipal attorney brought it. And there may not be like a policy where it's like certain types of crimes. It might just be like, they're so busy that now the municipal attorney is going to do it. And now suddenly that's an expungable offense, not sealable.
Maybe there's cases where it's just very clear.
But then just you see that like.
Oh, yes.
Yeah.
I'm just trying to find a path.
Or maybe let's hear from the
Yeah, I think
native
it's
cities and towns, and maybe it's not
an issue.
an issue. Maybe whoever prosecutes it should be able to
Just be able to.
sign a conversion. Right. Okay. Yes.
So, sorry, I'm still hung up on last year. Can you share with me how state attorneys in juvenile cases, only juvenile cases, use the sealed file, like the importance of opening up a sealed juvenile file for a state attorney? Like, what difference does it make in terms of what kind of charge?
I think it would be more, the scenario that popped into my head was, and we can think about some of the driving offenses. If a juvenile, say at 16, has been sent to diversion for the .02 ticket, maybe had more than two, and then at 19 or 20 has a driving under the influence. And maybe that county would generally send that first offense to diversion. But if there's two sealed DUI cases, that may not be the right approach in that case.
Okay.
And I would bring in our traffic safety prosecutor, because that is a particular type of case where we see when teenagers are involved in driving under the influence, it's highly repeatable as an adult. And I don't have the exact numbers, but Dennis Wigmans has said that previously in this room, and I know he could come in and discuss that. So that's something where we're seeing a pattern of behavior that, again, it just may not be the appropriate choice, but it could be, depending on the facts and circumstances. Though, and I'm gonna double check this just to make sure I'm saying this correctly, but as an adult comes in and there's a criminal record check, the juvenile record doesn't appear on an adult criminal record check. Like, we don't see juvenile sealed records on that adult criminal record.
But you have access to them.
We may be aware, but I'm just saying, like, just big picture, just so that you know, we'll see adult criminal sealed, the words in sealed, but we don't see a juvenile record, because juvenile records are confidential.
So why then do we need?
So
Yeah.
if this, but yes, so like if we are aware Johnny's had 3 DUIs already as a juvenile, then that may be part of our decision for charging. or for what we think is a good outcome for that case. And maybe there's information, and there's a lot of maybes there. And it, again, has to be for a criminal justice purpose, but it's just that the information isn't gone and no longer available. So again, the uses are not going to be all the time or relevant, but potentially it's very important information.
But who decides if the uses are all the time? Like,
Well, under for this sealing statute,
yeah,
we have to have a criminal justice purpose, and if we wish to, remember, we can access it, we can see it, but if we want to use it, we need to ask the court to use it. So there's that gatekeeping, yeah.
Any other questions for Kim?
Just had one,
Oh, yeah, I'm sorry.
Okay,
Yeah,
to
that's right.
point
You
out.
had a.
and and I don't know if I was just reading it, one of those moments of, if I'm reading it funny, on page 6, line 20, the start of sealing of sealed records, it says the court may seal any records that were sealed. And so my guess is, more suggestion might be just records that were sealed pursuant to the subsection prior to July 1, 2018, remain sealed or something to that. Like we don't have to ask the state's attorney to seal something that's already sealed. I think there's just a quick correction there.
That was before your time, Michelle.
Yeah, I think that was a find and search of like, because all the expungements got sealed, or expunge and seal, a find and replace. That just has a funny effect in that sentence.
This makes sense, yes, thank you.
That was the only comment. Otherwise, again, we support records be expunged, and I'm happy to get a little bit more information from the municipal ordinances.
I was just doing a quick search and I can't find like the official version of it, but just looking at like the Burlington city ordinances, there's not many at all that are criminal and tend to be on subsequent offenses. So third, indecent exposure within 6 months. Third, urination or defecation in public in 6 months. Third, noise violation in 24 months. So, I just want to say, I mean, just a quick scan, I'm sure, you'll have folks here who can talk to you more, but it doesn't seem as though there's a lot. Actually, as if they are saying. I just mean in terms of it's not a lot of statutes that or ordinances themselves.
It's not opening up things.
Right.
Yeah. Give you my concern. All right, well, I guess that is it for today, and tomorrow morning we're gonna have some fun. Beach 744. It may look on its face that it's not gonna be fun, but it's gonna be fun. So that's the rule change that we took over from the joint initial rules of the keeping state's attorneys away to help on the charges. Something. Anyway, it's important stuff, and we'll see everybody tomorrow morning. We're adjourned until 9.